So I just want to record an important update. So I've had some really good legal documents, representations written for me with some help from Velma, and she's made some really good work from my directions. And we've sent this into the courts in complaints and to the Office of Judicial Investigations. But also I've been circulating it around some of the campaign group leaders, like Jonathan N. Fuller, who goes to a lot of the court cases, and a lot of people read his page, particularly a lot of legal people who are involved in and around the cases. Joyle and Morhan from the Good Law Project as well. It's very clear that the Crown Prosecution Service have completely and totally ignored the Town and Country Planning Act and the statutory instruments for that act. Completely and totally ignored their existence because they didn't want to, because if they acknowledge their existence, they have to acknowledge that they wouldn't have been able to prosecute a lot of the campaigners who were putting advertisements in public. So instead, they've prosecuted a lot of them with criminal damage. And the thing with Angela's case is that she was acquitted, but they went after her to the High Court and got her convicted at the High Court. Now there's the issue with these tunnellers under Euxton Gardens who were acquitted, and now it seems that Max Hill has gone after those as well. It's like some game. He's almost retaliating. But anyway, I just need to update, because it was very lucky that I found the Tumultuous Petitioning Act completely randomly, so I didn't know about it. And then we managed. I'd actually done some work on immunity through the policing side of it, and through witness protection, and through assisting offenders, whereby they're given immunity, or if you're a Witness in Inquiries Act, particularly if you're the principal witness, if you're bringing the evidence. The whole study of immunity. Now, I found this just when I was searching for Tumultuous Petitioning Act. This is very important, and actually, it's relatively new. This, so I probably wouldn't have found it before when I was doing my previous research. So she's done this not long before we went into the COVID period. It's only like 2 or 3 years. It's only about three or so years old, or maybe 3 or 4 years old. So it's relatively new, and it's got information in it that I really was looking for about petitioning in the 1700s. It's a 13-page paper with a lot of cited research and documents. This is a Professor Karin Bowie, University of Glasgow, From Customary to Constitutional Right, the collective petitioning and right to petition in Scotland before the Union of 1707. I don't know what her affiliations are. I don't know whether Karin Bowie, this professor, would side with the police and prosecution and government, or whether she would side with the activists and the petitioners. She seems at least somewhat neutral, but I just want to point out a few things in the paper, what I want to draw attention to, which I think are important. Very important, in fact. She mainly points out this claim of right, which is meant to be a Scottish Act. It's very similar to the right to petition. It's got many clauses in it, and it's mainly based around this. I think she probably will have done quite a thorough investigation, and I don't think that there really is much more to add other than this particularly. There isn't really much to add in the 1700 period. It gives a lot of examples and reports. Now, she is not a lawyer. She's a professor of history, so she might not completely and totally understand the law side of it, although she probably will understand it somewhat. I would suggest to Karin Bowie, in her understanding of it, which is what we've been doing to expand our understanding of it in the application, is that the fact that there wasn't a police force. There wasn't a police force, before this 1700s. The Labour Party wasn't invented until 1900. But there wasn't a police force. I mean, they didn't even have the fire of the Houses of Parliament didn't burn down until there was a police force. There wasn't a police force when they were going after Guy Fawkes, that's for sure. So policing was a lot more publicly involved, members of the public. They did have constables and high sheriffs and all these figures, but it was the job and role on hue and cry for the public to the men of the village to assist to do the policing and assist the small number of authorities that there were, scattered around. And there were some volunteers who were unpaid and so forth, but they had a more active role in doing it. So because policing is investigating cases and pursuing criminals and bringing cases to the government, there is an immunity, there's a tradition of immunity behind that position. And we find this with witnesses now. Witnesses automatically get immunity, particularly under the Inquiries Act. And then when the CPS take people onto their side, the prosecuting side, the witnesses get immunity. And this is when you get informers and people, drugs raids, people are involved with criminals, but they're working for the police to help them catch them, and they've got immunity from prosecution. They can grant various levels of immunity, but they have to, within the prosecution, they're the ones bringing the charges and they seek the permission from higher up. Any prosecutor can discontinue a prosecution, but to get immunity for certain individuals is more like ongoing protection, and they have to get permission from higher up because it may well protect them from multiple or ongoing crimes or offences while they're assisting the police or part of the investigations. That's the framework you need to look at. It's a lot more important to just do this right to petitioning. And why do we have immunity? Why can't we be prosecuted? It's casework to government, and you're bringing a case to the government. And traditionally, you've got protections and immunities. There's an entire area of it, which is what all the police... We're assisting offenders when we have the police. The existence of the police is assisting offenders because all the legislation on the police is so they're allowed to break the law. So they're offending, but the law says that it gives allowances. So that's the same principle when it comes to petitioning, particularly important casework that gets laws made and changed. That context is not really included in these type of papers because they mainly focus 100% on petitioning. It's not really a paper about immunity or the right to petition. It's just a paper on petitioning and generally what types of petitioning people were doing. It does cover the law as well, but that's not its main purpose. It's more like a general study. So you can get this paper and you can read it. It's 13 pages. I think it's good, obviously. But I do want to scrutinise the professor in a few things. I've outlined things that I need to draw attention to. So they saw it as a dangerous and disorderly petitioning by enforcing standing laws against seditious words and unauthorised meetings against organisers. So the Scottish Government sought to repress what it saw as dangerous and disorderly petitioning by enforcing standing laws against seditious words, even, and unauthorised meetings, even people getting together. They did that through the church. This is 1633. So there's lots of reasons to create a law whereby people have immunity and protection, and these are acts and actions out of Parliament. Having meetings together and so forth, like I think Roger Hallam had online meetings, and one of the Green Party members went in there as a spy because they were planning to do certain actions, and then that's where I think when Roger Hallam got arrested, is he was a political party leader of the Burning Pink Party as well, and I don't think he got a proper trial either. And in this claim of right, it says that you can't be imprisoned or delayed a trial as well. But it adds more detail to the right to petition, including imprisonments being illegal. But there are some more important things in this act, things to add to what we've been building on already. So, it was dangerous. So dangerous. I mean, the Criminal Damage Act is mainly built around dangerous things that may be dangerous or potentially dangerous. Dangerous and disorderly petitioning. They saw it as enforcing standing laws against seditious words and unauthorised meetings. So they were even making people's meetings to be unauthorised, not only their free speech of words. So we know that definitely the right to petition without being prosecuted or commitments definitely covers all your free speech outside, not even in the Houses of Parliament. These are people who are putting petitions together and having meetings outside of the House of Commons. So, I would say that to Andrew Bridgen. So Scotland's claim, I want to go. This is the main discrepancy in the whole piece, and I don't know if this is an error on the part of Karin Bowie. I don't know if she's done this by mistake, or whether it was an intentional mistake, or whether I don't understand it. Scotland's claim of right was more radical in other respects, and this point it echoed England exactly. This allowed a collective political petitioning to re-emerge in Scotland with addresses to Parliament and the monarch. There is this differentiation between Parliament and the monarch. Both Houses of Parliament and the King, all of them were being petitioned, especially from 1700 to 1701, while England's 1661 statute remained in force. So this 1661 statute, the Tumultuous Petitioning Act, and the cultural norms of humility and decorum in parliamentary petition were reasserted. In 1701, Scottish political petitions tended to use forthright language, with an added rhetorical emphasis on the right to petition. In response, they're now limited by the claim of right from 1689 to the Union of the Scottish Parliament, continue to frown on assertive collective petitioning and use standing law to discourage popular participation in petitioning campaigns. I don't know what this standing law is. I don't know what she means by they used to use standing law to discourage it. Because statute law is the law that all the others are meant to be shaped around and that forms all the codified law, which is why you've got to have law where the police can break the law and do certain things. And why we have, through the Town and Country Planning Act, it's enacted and codified into law. Why, when you're petitioning, you can't be prosecuted for placing advertisements and delivering them to private properties, serving notices that are legally required to be delivered and served, even to private property. And you can publish in private newspapers. We've got this whole illegal campaign intervention, 5013C. And the whole thing with the Advertising Standards Agency on platforms and so forth. I won a legal argument with the London Evening Standard that they couldn't refuse my petition advert, and they agreed and published it. And I used the 5013C principle. YouTube claim that they will abide and comply with all the laws, but yet they've got a policy which kind of is saying that they can say you can't have this or that. But when you apply the law says that they can't have a policy and they can't intervene or punish you or restrict elections or petitions. I don't know what this I want to clarify what standing law she's referring to. Does she mean like the codified laws and so forth? Because all of those are actually, when you look at them properly, they are written to facilitate into it the right to petition, immunity and protection when you understand them properly. She only says to discourage, not to actually stop participation. So that I'm questionable about this here. And also, when she says in response, though now limited by the claim of right. But the claim of right's not limiting anything. If anything, when you read the right to petition, it clearly states that it's our right to do it and without being prosecuted. Right, or else to any commitments. And reading this claim of right, it adds even more clarity to that by confirming that you can't even be imprisoned for petitioning, right? So why would you be limited by the claim of right? In fact, if anything, it's confirming the complete legal immunity principle. I'm starting to wonder when she was talking about this 1661 statute remained in force here, that does put some limits on it, because the Tumultuous Petitioning Act puts limits on for how many people can sign it, and then whether or not it gets checked by a grand jury and the 3 justices or magistrate and so forth. So that's some procedures that are in place. I'm starting to wonder, why has she written this line here, now limited by the claim of right? It's not limiting the 1688 Bill of Rights. The Tumultuous Petitioning Act is. Now, there's one, I've put question marks here, because I think that Karin Bowie, Professor Karin Bowie, has picked up on something that I've picked up on. In fact, the name Bowie is almost like, bending a bow or shooting a bow. She notes out and points out here the distinction between addresses to Parliament, petitions to either of the Houses of Parliament, like, the Commons or the Lords, and petitions directly to the King. And also, later on in this paper, she draws attention to the fact that the wording of the right to petition in the 1688 Bill of Rights is the right of the subjects to petition the King, which is he, him, not they, them. It doesn't say Parliament, but she does agree that in most instances, people regard these as meaning to petition either the Houses of Parliament or the King. But the thing is, with the Tumultuous Petitioning Act, all petitions have got to be checked by these grand jury or 3 justices or the London magistrates, which is a commitment that you're held by. Now, if it was the right to petition the King and all prosecutions and commitments for doing so are illegal, all commitments that you may be held by, all rules or regulations or anything that you would have, then the Tumultuous Petitioning Act is one such commitment to have to be checked. Now, does Karin Bowie, has she noticed that if you had a loophole in the law, a niche, where if you were petitioning the King himself, then you wouldn't be held to the commitments of any other acts, which could be the 1661 Tumultuous Petitioning Act, which requires all the checking and vetting. Was that a clever 1688 loophole? Was this one of the very early examples of loopholes in the law where the educated and the clever might take advantage out of it, right? Because if you shoot through between the Commons and the Lords straight to the King, so to say, you're not held to any commitments. It seems strange to make that law to not be held to any commitments when we've got this Tumultuous Petitioning Act of 1661, which sets out these laws and rules. But we know that that act was abolished in 1986. So the petitions don't have to be vetted and checked now at all whatsoever. Now, what I love about this paper is this informing us about this Lord of the Articles. This Lord of the Articles is a brilliant revelation, because we don't have to have this Lord of the Articles vetting or checking petitions anymore. And currently, I'm finding that I submit many, many valid petitions to the Parliament House of Commons Petitions Committee, and they make up excuses like, oh, we don't understand what you're asking. The very flimsy excuses, we can't do this or that. I once was made aware of a petition to stop the 15-minute cities recently, which was rejected, said we can't do that. When you know very well that Parliament can make and change laws for anything governing all the councils of England, like the local authorities and referendums, petitions, acts and things like that. You could make a law to make it so no local councils can have 15 cities unless they can't even, put plans for them or proposals for them until first they ask all of the people and they get, like 51% of support first before they even, not even a consultation, like because a consultation is only your opinion, and they don't always regard the opinion like a proper vote on it. You could make legislation for that. The Parliament Petitions Committee, who is chaired by the Labour Party member from Newcastle, the lady, and Martin Day MP and various others, they're not very intelligent, and they don't want to be, because they want their own political party bias to apply. And I think that it is illegal campaign intervention similar to 5013C. And now that we know about this Master of Articles and the fact in this paper, Karin Bowie does note that really there is no vetting process anymore for petitions, and there shouldn't be held to any commitments. So I've actually put a complaint in now to the Petitions Committee, because they've rejected quite a number of my petitions, mainly on excuses, claiming they don't understand it, when at least 5 people have signed it to support it for it getting checked. And if those people can read it and understand it and not say to me, we don't understand it, then 5 intelligent people who have been educated in English schools have understood it. So I think it's party political obstruction and bias surrounding this Petitions Committee. I'd like to bring legal charges and prosecute them. That's one important thing that I've gained from this paper. So I don't know whether she's made an intentional mistake there. It could well be that she did that on purpose, because there is kind of a contradiction in the Bill of Rights in light of the Tumultuous Petitioning Act. It creates a contradiction. You can't be held to any commitments, yet there was a law pre-existing that petitions have to be checked. But yeah, it says if petitioning the King. And it could have said Parliament. They could have used that language, because the words Parliament appear in contemporary acts. From 1591, however, petitions to Parliament were regulated by an act. There was an act requiring the submissions of all petitions to the Clerk Register for review by committee, known as the Lords of the Articles. Wow, 1594. So we've even got laws about petitioning now, 1594. I don't know whether or not Professor Karin Bowie went back even further, but it seems to indicate the way that she's quoting people. She uses, in this paper, she uses a lot of witness evidence, testimony, pamphlets, things that people were saying about it. And they were all referring to a natural right or a natural law or a natural order. This could be well from the Celtic religion from before, when the Romans invaded, with the Druids, where people had immunity if they were challenging the chieftains or bringing a case to the Druids, and so forth. Or it could be, she quotes Rome as well. But the Celts never wrote anything down. It seems evident, or to me, from what I've read of this paper, the way that Karin is putting the case in this paper, that the kings of England weren't really too knowledgeable or up on this petitioning rights. At least they claimed they weren't too familiar with it. So I'm starting to wonder if it wasn't something that was brought over with the conquest. I'm starting to wonder if it was something that existed here already, or maybe it could be something Roman. But then again, the Romans left eventually. So that's interesting. And I haven't read the Edward Fitzgerald book, Smoke and Mirrors, yet, but that's I've got it. I haven't got around to reading it yet. It's very, very long. He's talking about natural law and natural rights, so I think he must have got some source material on that. But they were pruning out impertinent, frivolous, and improper matters. I would say that the Petitions Committee at the moment are pruning out anything that is opposed to their party policies or what they really don't want us to achieve, like blocking 15-minute cities. Or stopping the Stonehenge Tunnel. There was 200,000 signatures for that, and even a court case won to oppose it, yet the Department of Transport are pressing ahead with it. And really, firstly, usually when you petition Parliament about something in an area, they say petition the council first. There should have only 26,500 signatures gets a local referendum in Wiltshire. And you can even have a referendum to reform the entire council. I've drafted up such a petition due to how Stonehenge has been mishandled and biases in the strategic planning department. And I've written it up in a way that it's about Stonehenge, and so it should legally be able to use those 200,000 signatures from the other petitions, which have to be amalgamated together. And I've put this case to Richard Cluer of Wiltshire Council, importantly, and I've tried to get people to sign it. It's been posted on some large groups, but contacting the Stonehenge action groups they don't always respond. We've had success recently with this case where they banned wild camping from Dartmoor, and then there was an appeal. They said that camping wasn't a recreational activity, and then we pointed out that councils install benches in parks that are recreational benches, so even sitting down is a recreation. And there are also medical rights as well for erecting a tent if you're sprain your ankle or if you're tired or have got asthma. So now they've overturned that. But unfortunately, we're still having problems with this right to petition because it's quite a serious matter, immunity. And usually the immunity that the prosecution themselves use is through authorisation of the Director of Prosecutions and the Attorney General. And they grant different layers of it, but it exists. But they're the ones bringing the case. They're the prosecutors. You can use English law and criminal procedure rules and civil procedure rules to try cases as an independent. Then you are the director of your own case. And if you have any witnesses, surely you can grant them immunity because you won't be prosecuting them in your case. That's a very, very important insight to understand. The fact that the majority of legal actions are controlled by the government, but don't have to be, that's just a public service that's provided. They pull all the strings and call all the shots, but anyone can use and access the legal framework. You can have a private prosecutor and even private police and the procedure rules, and you can grant immunity. You choose who you grant immunity to. It's true that important cases, the Crown Prosecution Service can take over them, take control of them. That just means that they're directing the particular prosecutions. They direct the majority of prosecutions in England because we pay them to. That's the only reason. When you're petitioning the government, it is casework and you are bringing a case. And I really think that Karin Bowie needs to consider the history of before the police force existed, which is what we've done in our papers. And I should provide them to her and point out to Karin Bowie our case for the fact that Max Hill, the Director of Public Prosecutions, has completely and totally ignored and undermined the entire Town and Country Planning Acts in order to secure convictions against protesters who were placing advertisements lawfully. And they actually were acquitted by courts, but he went after them because he didn't like. It's almost like I think he and the police chiefs don't want us to have the rights. He's using the Crown Prosecution Service as his own personal political vehicle, unfortunately. But anyway, I'll try to get back to this, the things that I want to point out. So we've got this, frivolous, not important. Well, who decides whether something's important or not? Impertinent, improper. And then we got all they were trying to stop people having meetings in public or speaking freely about matters in public. So clearly the free speech, the immunity clearly covers outside of Parliament proceedings. Matters taking part in private, in houses or in the public, clearly. It's not just giving speeches in Parliament, like, illegal prosecutions by the King's Bench for matters that are only cognisable, decidable in Parliament. Well, if you're submitting a case for Parliament and gathering evidence for it, and that matter is only debatable, decidable in Parliament, then all the evidence you're gathering is in connection with that. There's no doubt about that. illegal prosecutions clause in the Bill of Rights automatically refers to where are illegal prosecutions mentioned elsewhere in the Act? Well, in the right to petition, prosecutions are illegal. And when you submit a petition, it gets debated in Parliament. It's a case. And these acts are talking about, your actions out of Parliament. The police bring cases, but they bring cases to a criminal court. And they have actions to do out of Parliament, where they're allowed to break the law and not be prosecuted. It's similar. All these meetings and so, and you can petition for a public inquiry, and this is the important thing that I need to tell Karin that we've looked into. When you're petitioning for an inquiry by the Inquiries Act or the previous Tribunals Acts, witnesses automatically get immunity, and if you are the person who gathered the evidence which is to substantiate such inquiry and lay it to a minister by petition, therefore, by the first provision of the Act, it appears to a minister that, evidence enough to substantiate the inquiry, you've got to have gathered some evidence and facts or evidence of public support and concern, which is the signatures and those signatures are evidence. They're regarded as evidence. So when you click the signatures, you're obtaining evidence. This is the pivotal legal point of it all. In the Inquiries Act, the evidence of the public support, which if you're petitioning for an inquiry, signatures, that is evidence exhibits. Now, evidence exhibits, you've got legal rights to collect them, and when you're doing an investigation, like in the Criminal Law Act 1967 in Part 4, 1 and 3, it's illegal to obstruct or hinder someone in such an investigation, or when they're pursuing criminals. To obstruct or hinder them is illegal to intervene. So if you're gathering facts or evidence, including the signatures, evidence of public concern about something that's illegal, can't be intervened in. And also, if you're publishing it in the newspaper, asking for witnesses to come forward to give more evidence and statements, you can't be intervened in. So the newspaper doesn't have the right of refusal, and neither does YouTube. If you want to promote it and advertise for witnesses through YouTube, or promote the campaign generally through YouTube, they can't refuse. And they have a policy on election misinformation, but it's mainly, I don't know why they use that term. They're trying to take away free speech by that term, or open debate, but essentially it's the 5013C rules that they're saying that they're enforcing on their website through their policy. And they're saying that you can't use the platform to intervene in democratic process or elections. And that covers petitioning, because there's a legal requirement to deliver notices and adverts through service of notices, even to private property. YouTube's private property, publishing on YouTube. So you are protected from intervention, and that's why you've got 5013C, which is, illegal campaign intervention. It all ties together. It's more clarified when you bring in, if you're doing a petition for an inquiry. Now, the thing with the petitions committee in Parliament, when they're vetting petitions, which they shouldn't be doing, according to this paper here, it's saying that really those laws were abolished of vetting petitions and having them checked and so forth. There is not that anymore. Like on 38 Degrees or Change.org when you run a petition, including the third party 38 Degrees intervening as well. They're merely a facilitator. Now, so Parliament really shouldn't be rejecting or refusing any petitions, really. And all matters are important. Or whether it should be redirected to the local council, they shouldn't reject it. Maybe they should have an interlinked website with the local council that automatically lists it on the local council. The local council websites are very, very difficult to sign, because they make you sign. It's hard to get it listed, and then they make you sign. They make all people who are going to sign join the website, which is a bit of a pain, and then sign it. But they agree that people from all over England who have the right to petition His Majesty's government and His Majesty's local councils can sign local petitions, particularly if they use services in that area or pass through that area or a business in that area. Even if you don't live there, you can petition. You're petitioning the local people for them to have a referendum. A referendum is counting every single opinion within a designated area. That's something that to have that is to count every opinion within an area. But the petition to have it is only to obtain that. You're effectively you're buying with signatures, or you're getting signatures from people who think a matter is so important that every single person in a certain area will cast their vote in a referendum. But who is that matter important to? Could be important to people who have businesses in that town but who don't live there, or people who use services in that town who don't live there. So you can get signatures calling for a referendum, and then every single person in that area will be asked using money from the council. When you're campaigning for the referendum, it's your own campaign that you have to fund, but you've got rights. That's quite important to note out. As well, what we're doing for the Stonehenge Tunnel, or trying to do for the Stonehenge Tunnel, but not a lot of people understand it. A lot of the campaigners don't really understand this petitioning the local council. I think that because in the 2011 Act for local referendums, it says all petitions on the same matter must be amalgamated. Well, surely all petitions to His Majesty, or His Majesty's government, should be amalgamated on the same matter. Many times Parliament will accept it if it's for a local area. I don't know why they had that debate on Stonehenge Tunnel. Why they didn't make them have a referendum locally first anyway. I don't think they wanted them to have one. They're having a referendum in Atlanta over this cop city at the moment, where they're all going around and collecting signatures. But America also has got some very questionable regulations around it that's making it quite hard for them to do it. So here we've got, this is very, very important. This is brilliant information, this lot of the articles. And we know that petitioning and protection immunity must include outside of the Houses of Parliament, meetings, free speech, delivering to private properties. It's a legal requirement to deliver notices. And then we know that we've definitely got, because of the underlying institute law, they have to codify it into the Acts. It's only codified into the Acts because the underlying institute commands it. It must be, or it's illegal contrary to the law. That's why the Town and Country Planning Acts facilitate for all this, and all everything the police do, really, it's casework to the courts. And it is the Crown Courts, or the Magistrates' Courts, is the Crown emblem. The police is the Crown emblem. But the police don't really like to admit or accept that other people can do police work, and it says in the Criminal Law Act that any person can pursue criminals, and also got citizens arrest powers, and we can petition for an inquiry. The Petitions Committee always reject petitions that are anything to do with judicial matters, whether you want to appeal to the Lords for you see, they abolished that Gordon Brown abolished the Appellate Jurisdiction Act, right? Which was the appeal to actually the Lords, not the Supreme Court. But you never needed that. People were petitioning to appeal convictions or to the King on any matter, or even for prosecutions in the High Courts, before those acts were even enacted, even before the Tumultuous Petitioning Act was enacted. So we know that none of these acts create petitioning or invent it. They're not saying it exists and you are allowed to do it. It existed and we were allowed to do it before. So the right to petition, that is the right of the subjects to petition the king, it's the right of the subjects means all of the subjects, which means the matters. The topics, it's the right of all topics and matters and issues. And the people, without being prosecuted. So the right to petition is creating the immunity. There is no doubt about it. And really, it is casework to Parliament or the Lords or to the King, but the entire... One thing you've got to realise is that we do have the legal process. You know, people are getting fined for crimes way back here, and we have the police volunteering, the public volunteering to be police, right? You know, and hue and cry. There's a lot more public engagement, you know, so you would need immunities in important matters. And the main thing to understand is that it is legal proceedings. The one thing that this act, this is another major point, that this act indicates that petitioning is and was, it originated from origins, natural law and origins from previous cultures that the kings weren't too knowledgeable on, but how they incorporated it into the country, it is a legal proceedings. It's got magistrates, judges and juries, so it is an officially established, and I use that word very pertinently, established, legitimate and official form of proceedings in this country. And just like criminal proceedings or civil proceedings, and they were using proper judicial process. Well, they were using proper judicial process and proceedings for it. So it's as significant as a police investigation and trial, or a civil case, or marriage and divorce, right? And that is what the authorities don't really like. And it's also acknowledged that as part of those proceedings, there are preliminary proceedings, like the entire existence of the police force doing investigations is not in a courtroom, although they go to the courtroom for warrants and so forth. Having meetings, free speech, advertising and promoting, or even possibly protecting the things that they have an interest in getting the government to leave alone and protect before they're destroyed, or else there's nothing left there to protect, surely, while you're trying to use diplomacy through the petitioning to achieve another outcome, like the site's not getting ruined, like with these Euxton Gardens tunnellers. So, you know, the Petitions Committee at Parliament, how they've got the website set up, you can register it online, but you're only limited to 50 characters. They don't let you put external links. All this vetting, rejecting them, which they're not supposed to do anymore, is kind of insulting and undermining. They make out that it's not really, and they never back you up. They've got a Privileges Committee in the House of Lords and a Privileges Committee in the Commons. Where is the Privileges Committee for public petitions? You know, and maybe you can see your MP, but they don't seem that knowledgeable on it or too eager to assist. You know, and the Petitions Committee should really help, but they actually don't really want you to publish many of these petitions. They're rejecting ones that are very clear. It's very clear what they're asking. And if there's any other information that didn't need to be in the petition, but is worth reading out, they should be letting you attach evidence, because it is a case, and they're trying to omit links, saying that they might be untrue or incorrect. The petitions, the vetting stage doesn't decide that. You're trying to get it debated in court. It's almost what YouTube and Google are trying to do now with their, you know, misinformation policies. They think they're the judge and the jury. They're the courtroom. They think that they're judging whether your case is right or wrong before it gets judged. It's almost like the police, you know, the conditional offers and so forth, without going to court. You Evidence and all attached papers are examined in court to decide whether they're true or not, or false. That's the point, right? The trial. I don't know why YouTube are trying to claim that things are false information or not, or even Parliament Petitions Committee. If the Parliament Petitions Committee are deciding what's true and what's not true or whatever, then why aren't they themselves debating the matter? It wouldn't be debated in Parliament whether it's true or not. This is the thing. They're trying to kind of like almost create another authority, but they're not. We don't have loads of articles anymore at all. And what people are doing is they're trying the information. In any civil case, you try the information. Now, if they're saying that the Parliament's Petition Committee is almost like when you submit online to the Small Claims Court, and a judge can say, sometimes says whether it cannot be heard, but that's the same judge who looks at it to say whether it cannot be heard before it's heard. Are the MPs in the Petitions Committee, are they trying to say, well, we're just a couple of the MPs and we're going to decide, we'll be debating it with them in the chamber, but we're deciding, whether we're going to debate it or not like a court. But I wouldn't mind, but a lot of the time they're just lying. Like they're saying, oh, we don't understand what you're asking when you put it. And you use all you're only allowed to write so many words because they put a cut-off point. You need to write so many words a lot of the times to justify with them that I can petition for this through this act and that act, and I am right to be petitioning for it. I can legally do it. And by the time you've said that, you've used all your words up. And then they say, we don't know what you're asking, because you haven't actually said, I'm legally justifying that I can ask for all these things through this process, but then, then write the facts about the particular case, like now you've set out that you can have it. They're basically parrying with you, and they are lying. And this is what Max Hill has done. Max Hill has lied with his prosecutions in order that he can have them. You see, the Petitions Committee are making very flimsy excuses up that you can't have a petition, that it can't be heard, and they're limiting even the information you can put on there. While Max Hill is all the things that you can't do, all the things that Max Hill can't do, that like the Petitions Committee, the court should be saying, you can't have that, Max Hill, you can't bring that one, you can't do that one, you can't do that one, right? Like the Petitions Committee is saying, you can't petition this, you can't petition that. Why aren't the courts saying to Max Hill, you can't bring this case, you can't bring that case, you can't bring that case? They're supposed to check. But what they're doing to Max Hill is, he's completely ignoring half the law. Like the Town and Country Planning Acts and statutory instruments that says that, this is not a crime. He pretends it doesn't exist, and he does it through criminal damage. Just because he wants a conviction. They let him have that. So what they're doing is they're letting him. He's a psychopath. He's psychopathic. And no one's stopping him. No one's actually trying him. No one's trying to bring criminal charges against him. No one's bringing criminal charges against him. But what he's doing is he's bringing criminal charges against us. He's got his immunity in his job with his witnesses and his police officers. But our immunity, they're saying it doesn't exist or it's not valid. And they're even imprisoning people without a trial against the law. Not only are they imprisoning people without a trial against the law, you can't even be prosecuted. And they're even rejecting and obstructing our petitions. Max Hill is the tip of a very deep iceberg. And it is all tied into the fact that we are bringing a case to the government with evidence if required, and the right to obtain that evidence and try that information and deliver notices to the public legally required through newspapers, in public advertisements. And I would suggest as well, not only the free speech in the meetings are protected from prosecution like Roger Hallam's. If the case you're bringing is to protect something, it's not going to be any good if it's destroyed in the process while you're waiting for the case to be successful. If you were going to use the immunity for anything at all, you would make use of it to protect something that you were bringing a case to protect, because that is logic. If you are a large number of people are bringing a case to protect something, then if you had any immunity at all, you'd use the immunity for protection, so you could protect what you're protecting in order to while you were bringing the case to Parliament. So that's one important part of it. So that's that. I haven't pointed out on that page. Here on page 4, we've got Privy Councillors tried to make the petitions more acceptable to the King by urging the organisers, unsuccessfully, to petition only on the service book without any criticism of the bishops. So they wanted to they didn't want bishops to be criticised. They wanted to try and shape and trim and prune these petitions to bend them to the will of what they wanted to be said or not said. This is what Parliament are doing. They don't want any mention or criticism of MPs or of any persons mentioned or government officials. But they were unsuccessful in trying to stop them doing that. So you can mention people, because ultimately, if you've got a local council, petition is case and petition is asking for something to the authorities. And the local monitoring officer of a council who deals with complaints against MPs, that is a certain complaint that you can put, and you could have people agreeing with that and signing it, witnesses who also believe that. It still is a petition, effectively. Whether or not it's a public petition, well, do you have the right to ask for witnesses and let the public know about it? Not just the monitoring officer. In the newspaper, can witnesses come forward if they've got any evidence of the councillor's misconduct? And so it is really a petition to the council through the monitoring officer, not necessarily asking for a new park or, save some trees or whatever, but it is petition to local government on a matter. They really don't like this judicial aspect of it, and Gordon Brown really tried to put a stop to it. But you can't, because you didn't need the Appeal Jurisdiction Acts, you didn't need the Bill of Rights, and you didn't actually need the Tumultuous Petitioning Act to petition about all these matters. They were doing it before. The Petitions Committee ministers really are trying to protect themselves and their image and integrity, yet all they do is lie and commit more fraud. So that's worth pointing out. The current Petitions Committee in Parliament is atrociously managed. They're not meant to have vetted petitions. It's political party bias. It definitely sets out, it definitely brings into the light that these petitions are very, very well established legal proceedings, and to be regarded as that, and the preliminary parts of them. In the following 1662 Parliament, this is after the Tumultuous Act, it condemned that wild and rebellious courses arising, courses. Well, they use that word courses in the 1688 Bill of Rights in the illegal prosecutions part, illegal prosecutions by diverse and arbitrary courses. Legal prosecutions by the King's Bench for matters that can only be decided in Parliament. Well, the petition that you collect evidence on and compile and get support from the public and then promote it and then hand it in, surely is something that Parliament are deciding, else it wouldn't have got there. Wild and rebellious courses arising from 1637, including mutinous and tumultuary petitions. Wild and rebellious. This is before they decided to invent immunity and protection, even from being imprisoned. 1637, mutinous and tumultuary, wild and rebellious. So clearly these things were happening, but still they thought it a good idea to invent the protections and immunities which would cover these courses, wild and rebellious courses, mutinous and tumultuary, which is like, again, the political parties really don't like people who, their own voters, to sign petitions that are asking for things that are contrary to what their current political party policy or direction is. They really don't like that. It's like stealing a shepherd's sheep. Office holders were required to declare that such petitioning was unlawful and seditious. So, unlawful and seditious, unlawful would be referring to wild and rebellious courses, including mutinous and tumultuary. So this is all covered at the later stage by the right to petition and why it is enacted, for sure. There's a pamphlet going around 1669 where denied the very liberty which is the privilege of all free subjects and the birthright and native privilege of all men. So this is definitely something that this is a principle of immunity that was regarded as pre-existing. Anyone is allowed to supplement or make protestation on the law of nature and nations, just an internationally accepted civil liberty, but a natural right. Well, that's what Richard Vobes has been talking about in his videos, particularly with Edward Fitzgerald and Charles Wells of Canada, who has literally been into court in Canada and proved that majority of the Canadian laws and fines aren't even enforceable or valid. And he's actually won that in court, this Charles Wells, if you watch the Richard Vobes programme on YouTube. This is helping establish why the immunity was invented and what for. The council questioned and imprisoned several women, spurred on by a letter from the king that identified petitioning and field conventicles as insolent, seditious practices and urged vigorous suppressing and punishing of the ringleaders. Well, that's what happened to George Hallam, and they even had a go at Gail Bradbrook. Petitioning field conventicles, so surely out in the field, which is out and about. These activities are definitely, activities that are out in public, particularly when it's regarding all these wild and rebellious courses. Roger Hallam, the punishing of the ringleaders. Roger Hallam, he was a leader of a political party. He got prosecuted for his radical ideas of promotional radical promotional advertising practices for his campaign. Extremely radical. Here on page 7, I wanted to point out the Lauderdale regime required that any complaints to Parliament were to be reviewed by the Lords of the Articles, with any oral complaints being referred immediately to the committee. So even when people are making oral complaints, they get referred to them. So, when you're contacting other departments in government and even local councils and so forth, maybe even the Advertising Standards Agency and maybe even the Constitution Society, people like that, maybe they should be referred. We don't have a Lord of Articles committee anymore. The Petitioners Committee is just meant to basically, do the secretarial work for it, not make judgments on them. But the MPs seem to believe that that is their function, particularly Martin Day and that Newcastle lady from Labour Party. This was consistent with the aims of the 1594 statute, but was seen as a barrier to open debate. Also, if it was orals being referred, they might not have sent the correct message, or they might have edited or modified them. This reminds me of Fort Lauderdale. When it says the Lauderdale regime, it reminds me of Point Break, in the Point Break film with like Fort Lauderdale. You know, he mentions Fort Lauderdale, but that. I've used that example of that film for the immunity when you're investigating, because they've got that undercover police guy who's with some drug dealers and he's undercover, pretending to be their dealer, and another police unit comes in who doesn't know that he's there, and they arrest him with the drug dealers, and they discover that he's an undercover police on the police, and he's not happy about it, and they ruin his undercover investigation. This is like injunctions. This is not injunctions, but this is like when two separate cases clash, the needs of other cases. And this is the point when we're petitioning Parliament, when we've got a case and the police actually aren't pursuing other criminals. They're actually regarding the case itself, the participants, as criminals, not even accidentally getting them while they're investigating something else, which is not claimed as political. This is the problem with Max Hill. So, signatures were limited to, or in England, collective petitioning to King and Parliament was regulated by statute, but the subject's right to petition was defended by the House of Commons. They were trying to take the right away. The House of Commons defended the right to petition. The 1661 Parliament restricted tumultuous and other disorderly soliciting and procured of hands of collective petitions, redress or pretended grievances in church or state. Pretended grievances, so that's like, when you don't even really have a case or anything, or false claims. False claims. That's like Andrew Bridgen, I suppose, with Matt Hancock. He's doing false claims, but I was kind of like, if they've both got immunity in Parliament, they're bringing claims against each other. None of my petitions to Parliament have ever been pretended. They're all absolutely legitimate, so they've got no right to reject them, really. Signatures were limited to 20 unless a petition had the approbation of 3 justices of the peace, a grand jury, or the magistrates of London. I'm guessing that's not one magistrate. It says the magistrates of London, because you wouldn't have 3 justices or the grand jury or the magistrates of London. Signature limited to 20. Well, why though? Is it only to check and vet them? If they didn't have this Lord of the Articles, who was vetting them for reasons just to make excuses up that they didn't want to have to hear these cases and to fail them, like the current petitions committee are doing unlawfully, we're limited to 20. I wonder if the real reason was that if there was a very, very, very large number, I know some murder cases or very complicated criminal cases might have a lot of documents to go through and a hell of a lot of documents, but you could easily outweigh one of those cases in volumes of paper material. If you were, getting thousands and thousands of signatures, who would count them all? And check them, particularly when you're meant to be amalgamated together and so forth. Maybe it's because of the volume of all the people who are supporting it, not just like, the people who are attending in public, who, there's a large gang or a large crowd turning up. Maybe this getting more grand jury or more justices to examine these petitions. Maybe like you need the police force to turn up to manage a large petition, like a petition protecting HS2 sites, trees and so forth. And maybe the police should be turning up to make sure, mediating diplomacy in between, not being paid by Johnson to protect his HS2 projecting interests and stop them from hindering it. If they've got a right to protect it while bringing a case, then, this is it. The law now is that you can't have prosecutions or convictions or imprisonments. Doesn't say that you can't have, people turning up to mediate or spectate or check people who are right, or even send diplomats from the government to negotiate. All the money spent when, abroad, overseas in another country, all that money on a tank. How much money is a tank? With all the money that a tank costs, how many millions? Hundreds of millions for one tank, advanced tank, that could get blown up in Iraq. You could send diplomats to negotiate with Roger Hallam and Gail Bradbrook, but the government are interested, or even in public to openly debate with them at the events and so forth. But then again, we've got all these rebellious courses, which clearly they knew about, but yet they still chose to enact the immunity. Petitions were not to be presented by more than 10 persons. This statute provided the basis for a proclamation against autonomous petitioning issued in December 1679. This aimed to quell petitions calling for a meeting of Parliament. So this is another thing. This is very, very important as well. I've read the Peter Ackroyd book, Histories of England, Volume 3. And they didn't always have a parliament, with a long parliament. So before then, the king actually called on parliaments. They didn't even have parliaments, they just had the king. Only petitioning the king. This petitioning process, this established legal framework, these legal proceedings, which are very, very important legal proceedings, they predate full-time parliaments and ministers, Andrew Bridgen, Matt Hancock, even Martin Day. They predate there being a parliament. In fact, some of these petitions are calling on them to have a parliament, to hold parliament, to call the king, to call parliament to come and meet, like Oliver Cromwell was an MP. So it's actually more important than parliament, because you don't need the parliament, and it predates it, before it, until they start getting local people who they would elect through an electoral process to turn up and represent them all in the parliament when they had it. The importance of these procedures actually predates MPs. And now we've got MPs sat in a committee who are rejecting these petitions. Mind day. Rejecting them on making excuses up that they don't understand them. Yet, how can you collect, 5 or 100 or 1,000 signatures if those people didn't understand it when they read it? They must have understood it, or they wouldn't have signed it. These people have got no right. Now, Max Hill, the Director of Prosecutions, is beyond himself. I've heard King Charles say that, they're beyond leaders now at the World Economic Forum. Beyond leaders, beyond trillions. This is beyond MPs, beyond ministers. We petition for that the ministers can even be there to represent us, let alone elect them and debate our matters. Because that's the only reason they're there. Yet they're sat there rejecting our stuff, mainly because Keir Starmer and Rishi Sunak only want to do what their political parties want to do. This is a well-established legal procedure which predates Parliament turning up and has immunities, more important immunities than the CPS can bestow on witnesses. Rigour of the law. A first wave of petitions presented from December 1679 angered Charles II, especially as some had not secured the required permissions. 1679, so that's before 1688. This is because they were clearly they were circumventing the Tumultuous Petitioning Act and not following the procedures. But then again, the first wave of petitioning, especially some had not secured the required permissions. But this is it. I've got a feeling that Professor Karin Bowie has figured out, like I have, that why does it say it's the right of the subjects to petition the king, and all commitments and prosecutions for such petition are illegal if you're petitioning the king? Is that both houses of parliament as well, His Majesty's government, or not? And if it is the king, he, him, then does that mean they're not held to commitments of the Tumultuous Petitioning Act? These were not prosecuted, but the petitions, with a second wave in April-May 1680, stimulated a small number of shires and boroughs to present loyal addresses expressing their abhorrence at petitions. This led the Commons in 1680 to approve a motion confirming the subjects' right to petition and rejecting the treatment of petitions. So that means that even though the public, the larger part of the public, or some of the public might have shown their dissatisfaction at the petitioners or petitioning, which is almost like this is Max Hill. This is what Max Hill's probably claiming. Oh, well, it's annoying everyone. Like, just stop oil now. There's the just stop pissing everyone off movement. All these people who are getting annoyed. This is saying that they decided that, even though there was lots of members of the public complaining about the petitioning, it was upheld. It was upheld. So, and then this is before the immunities added and created, both in this this claim of right and in the right to petition. So Max Hill has got no place to claim that he's the Director of Public Prosecutions. He's acting on behalf of the public. It's the public. Because, Ian Bray got acquitted by a jury, even though none of these prosecutions are lawful anyway. Doesn't matter what. The fact is, there's a case and the public is signing it. Which is like, or else you wouldn't be able to have a jury hearing a case with, 12 people. They're meant to be representing the whole people. You've got the right to bring the case with the immunity and protection, regardless of what the wider, because that's why it's to be judged in Parliament. And they've got their right to oppose it through these means and mechanisms without having you convicted as a criminal or intervening. So that's important as well. And this is on page 9 at the top. So this is important to, Max Hill claiming that, doing it on behalf of the public. Following the session, addressed MPs included thanks for defending the right to petition. Ignoring customary liberties to petition for justice and relief. As the Earl of Perth commented, measures need not be too nicely kept with the Scots, ignoring customary liberties to petitions for justice and relief. So they were kind of ignoring Scottish people. The government imposed stringent restrictions on petitioning in the period from 1661 to 1688. Whereas so now it's saying that this is from 1661, from the tumultuous to 1688, whereas discourse and practice in England included affirmations of the subject's right to petition Parliament and the facilitation of public debate between partisan groups, loyal addressing, and in Restoration Scotland confirmed the relative absence of adversarial petitions. I'm not too sure whether or not this Professor Karin Bowie is a fan of the immunity and the statutes. She seems contradictory. Again, I want to know whether this is an intentional mistake here, or whether I don't understand it, or whether she's done it on purpose because of the contradiction in the Bill of Rights itself and the Tumultuous Act. Although it doesn't matter now because the Tumultuous Act has been abolished, and many of these older ones. Though the facilitation of public debate between partisan groups, loyal addressing, though this clause specified only petitions to the monarch. This is it. Right. So on page 9, in this second major paragraph here, though this clause specified only petitions to the monarch, the clause came to be seen as encompassing petitions addressed to Parliament. Well, this is the exact thing that I pointed out here. This whole thing, the wording of the right to petition, is the right of the subjects to petition the king, he, him, and all commitments are illegal. So does that mean that all the Tumultuous Petitioning Act rules were illegal as well if you were petitioning the king? Not to be commitments. There were only commitments if you were petitioning either of the Houses of Parliament, right? That's interesting. So, she's pointing that out as well, but she says that it came to be encompassing petitions addressed to Parliament as well, and the Lords. But now at the moment they try to ignore the Lords, and they try to not want to forward them to or acknowledge it. So this Professor Karin Bowie, right? She is very much, as a professor, very aware and pertinent of the exact things that I am, and that I believe the majority of people are when they read these clauses. Now, she is not a lawyer, she's not a law professor, but nonetheless, she's a professor in history, which is a high academic standard. And she also, in this 13-page paper, I highlight the points that I also find not only relevant, very, very relevant and important, and how that is applicable currently, but she points out the contradictions and discrepancies that I myself find. But yet this claim of right seems to clarify. And when you take into account the big picture, all the other things are happening in the country, all the policing is done by the public and all these type of things, she doesn't, it would be interesting if she did a 13-page paper on prosecutions in England and Scotland through the 1500 to 1700 period, on hue and cry, who engaged in the people who caught the criminals, given immunities because they were, helping the authorities, the proceedings, and what relationships they had with the constable of the areas and the high sheriff and these voluntary people, and the proceedings and how the evidence was handled, or if they even had evidence in those days other than witness. Mainly, it's all going on. They didn't have cameras in those days. If in the Civil War, if the soldiers would raid a house and steal all their artwork during the Civil War, people would petition to Parliament and say, we want compensation. The soldiers stole our things and, so much money. What evidence would they have? In here, there's something about false petitions, lying petitions. What evidence did you have in those days? All you have is a witness statement. You get people to sign it from the village. Mrs. Tribble's paintings got stolen. I'm John the Butcher, and someone else saw it down the road, and it's all bits of paper with writing on, statements or verbal, written down. You don't have fingerprinting and all this or that. Now, you might get the High Constable to, go to the soldier encampment or whatever, find out where the paintings are, follow investigations and so forth. All that early primitive evidence gathering, exhibits of evidence, statements by a individual that is for a legal case is evidence in proceedings. And this is why your signatures are evidence, particularly like in the Inquiries Act, when you have to show evidence. And when you're collecting that evidence, you're collecting evidence in an investigation for an inquiry. It's like the police with witness statements, but you promote. You have to ask who's supporting it, and there's an advertising aspect involved. In the police work, there's a minimal advertising aspect involved. It's a small part, but the police have got their own press office. Anyway, the police have a press office. They like to put out their own stories. We're starting to wonder whether or not the police are using all of these immunities and setting up and staging accidents. Mysterious things are happening. Whether they're swaying the public opinion. If the police want more security cameras, they need evidence for the Parliament to approve the cameras. Evidence of concern. If there's more robberies, if there's more incidents, it's evidence of public concern. If it's in the newspaper, stirs up a whole hoo-ha, then it's a strong case the police are making for want to get more security cameras. Although they didn't officially submit it by petition, they just applied to their own police procedures. Oh, we'd like some more cameras, please. We don't see much concern for that. Oh, there will be. Well, actually, if they were policing properly and there were no more criminals left, we wouldn't need any cameras. Everyone were well behaved. But yeah, they like cameras watching people and spying on people and more blocks and barriers. From the behaviour and conduct of Max Hill, lying in public office, completely ignoring two complete acts of law, the Petitions Committee rejecting petitions that they should and could very easily understand, claiming they're stupid and they don't understand what it's asking when we don't have Lord of Articles anymore. This is treasonous. It's perverting the course of justice. I would suggest that petitioning, it's a legal procedure which involved justices. So if it's been perverted in any way by Max Hill or the Petitions Committee, you see, the Petitions Committee are trying to keep petitions out, and Max Hill's trying to get his affidavits in when they shouldn't be in, they should be out. So he's getting a lot more than convictions than what he should be getting. In fact, he shouldn't be bringing the cases. And the Petitions Committee are having to debate less and less petitions because they're just rejecting them, And then we've got hindrances on the platforms now. The right to publish to public is being undermined by Mark Zuckerberg illegally. YouTube, when we go into the advertising rights and campaign intervention, which is the next thing I'm wanting to get on with the YouTube channels. This is it. Monarch came to be seen as encompassing petitions and addresses to... So, the clause did come to be seen as encompassing petitions and addresses to Parliament, both houses. They won't let you have any to the Lords. They really don't like it. They don't want they don't want it on the petitions. The Parliament Petitions Committee website, it says Parliament, UK Parliament. It doesn't say the Commons, although it's in green, but they should publish petitions to the Commons and Lords. They don't really want you to believe or know that you can petition the Lords. I don't think Gordon Brown, who's Scottish, by the way, you can't stop people petitioning for appeal of a conviction to the Lords, because the Appeal Jurisdiction Acts didn't invent it. You could petition about whatever you wanted through these basic procedures to either of the houses or to the King, right? unless it said that, the king had to deal with, appeals for pardons and acquittals and so forth. Tim Harris has pointed out the bipartisan nature of the 1689 English Convention meant the revolutionary settlement and confirmed existing laws and liberties, while the more Whiggish. So it seems that it is identifying it's acknowledging that the principle of this immunity and the petitioning process itself and these rights are of a Whiggish origin. So that means that, the Liberals, the Whigs are the Liberals, the oppositions to the Royals. So the whole thing is kind of, the whole basis of it is more identified with the Whigs, which is then you're looking at why our area, has had our ancient site built on and they banged the imperial chemical industry there. Our side sided with Cromwell against the Royals, and I believe it's been punished by spoiling the area, particularly because it's got very prominent ancient sites here that don't really get a lot of acknowledgement, very beautiful ones that have been ruined. And, this imperial chemicals industry, Syngenta now, there's a lot of campaigning against that, but they're still expanding. There's a continued attack. These powers, these royal powers, have now taken ownership of all of the major corporations and businesses. They're putting aeroplane engine factories on industrial estates that the public opposed to multiple times. They still managed to get them built. And call them names like it's arranged, so it's like Incora, when it's just, the stone's throw from our ancient site that has had the side quarried into and spoiled, like mockingly. They like to mean something with their businesses and actions now. And in order to fairly oppose these multi-trillion-dollar companies, we don't have anywhere near as much money as them because they've taken possession of all the money through their business transactions. So all we've got is our rights. And now they're not even wanting us to be able to use their platforms when it's the main communication method. And when we get annoyed because we don't have money for billboard adverts and magazine adverts, and they're not giving us free adverts in the newspapers anymore for petitions, they seek to brand us as criminals. People like Max Hill, even his name, Max Hill, is when he's, clearly on the royalist side. It's concerning. Now we're on page 10. I didn't really want to take too long, but it's ended up being... I haven't marked anything on that page. There's a few bits on there. There's not many left to go through. Pamphlets took a case a step further by arguing that petitioning was a natural light. Maybe that's referring to the psychedelic experience, which projects the inner self and the whole spiritual. Maybe there are ties to the Whigs and the Celts pre-conquest. Then to the ancient groves and sites where you might commune with the spirits, the subjects, the illuminated subjects and spirits that we might commune with. This is why the whole legal profession refers to chambers. My legal chambers, my chambers. I thought that was worth pointing out there. Reflecting his experience as a signatory. This John Locke's second treatise, published in 1689, but reflecting his experience as a signatory of a London petition in 1680. This was before the Bill of Rights then. He argued for a natural right of the people to appeal to Parliament to redress grievances and prevent the abuse of royal power. So it's almost as if this Professor Karin Bowie's found evidence of something which may have contributed towards the 1688 Bill of Rights being enacted. This John Locke's, his second treatise, he published it was published in 1689, but it reflected his experience from 1680. He may have written it earlier than if it's from 1680. He says it's arguing for. This could have just been before that it was actually given royal assent then, because it's 1688, 1689, isn't it? It says 1689. It was published in 1689, argued for a natural right of the people to appeal to Parliament to redress grievances and prevent the abuse of royal power. So this is a person from that time talking about it in the correct context. So this is actually like going back in time and asking someone, what was it for? But then again, you could ask someone now, walk into London and ask someone, oh, what's this new policing bill all about? Extinction Rebellion have been kicking off and they're trying to stop them locking onto everything and so forth. Well, can they do that? Is it been held to a commitment? Haven't they got immunities already? Argued for a natural right of the people to appeal to the Parliament. Well, also natural is like your own thoughts and ideas, your own freedom of expression and thought, natural as well. Like that's the subjects of what you want to talk about. To appeal to the Parliament to redress grievances. Well, that's how they've got it worded in the American First Amendment. So the right to petition is for redress of grievances and to prevent the abuse of royal power. Well, isn't the abuse of royal power Parliament as well themselves? And isn't abusing the power them enacting loads of laws to try and stop us petitioning to redress their grievances and even promoting them as much, and freedom of speech on the websites, which is why it was enacted. They were trying to stop even people having meetings in private and speaking freely in private, and they were labelling the petitioning as rebellious itself. So they still went ahead and enacted it is immunity. It's making intervention unlawful from the prosecutor, which is Max Hill. It's Max Hill. So this is what it's for. And also it says in the Scottish in the claim of right that they can't be imprisoned. They can't be imprisoned either. The king assured his subjects that he would not discourage the liberty of petitioning. Rishi, it'd be all right if you said, Rishi Sunak assured his subjects that he would not discourage the liberty of petitioning. If the same is done in an orderly manner. Well, it's all being done in an orderly manner now. They're uniformly slow marching with a spotter at the front to make sure they're all safe. They're uniformly marching in an orderly manner in the road. And they're also orchestrating to protect the places that the government are continuing with, like Stonehenge Tunnel and these Euxton Gardens and so forth. And the Extinction Rebellion are even organised into broadcasting, scheduled broadcasting and interviewing the public. It seems like it's a professional operation by the BBC, only instead of supporting the government and what they're doing, they're actively trying to stop them and oppose it. In fact, trying to stop it happening while they bring a case for it to be stopped. And, stripped down of all money, then if you ain't got the right, you ain't got anything. So some of these big corporate companies now are having more effect and influence on people just through their own commerce and business on the sheer volume of money that they've made and can influence through adverts for commercial purposes. Yet they've got their billboards on the street, on every corner, on the side of bus stops. They've taken over the public domain. They've taken over the entire public domain and area. Everywhere you look, on the side of buildings and billboards, money, 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 money. Yet our right now doesn't seem to buy us that. Even though we don't need the money, you need the right, because the right lets you do it. You get consent from doing that. Now, Max Hill, unfortunately, is not on the side of the people and their rights. He's on the side of the corporate interest. He thinks money buys you the right to do it, not the law. In fact, he's been completely ignoring and undermining two entire acts, the Town and Country Planning and statutory instruments, when they clearly provide provision is made codified for this. And I believe the trespassing laws, the service of notices provides for messages and notices that have a legal requirement to be delivered, even to private land, to be delivered or even attached to the building. So you can be on private land without it being trespassing. I don't know about the time frame from it, but I would draw attention to the codified law for the police. How much of the speed limit can you go? Well, you can go as fast as a vehicle will go. Has it been measured, this? Has there been a contest between police? What does the law say? How fast can the police car go? 100 mile an hour, 200? There is no number. There is not even a percentage in the law. It says the speed limit doesn't have to be observed. So what is the length of time a petitioner with immunities can be on private land to deliver an advertisement or notice or a singing telegram or have Gail Bradbrook pop out of a birthday cake to the Max Hill, or, Keir Starmer. This is it. Orderly manner. Could not always in law prescribe the ways and methods of the subjects. This done set with resistance in the Privy Council with the petitioning. Only a narrow majority of 13 to 10 voted to issue the King's proclamation rather than quieting the petitioners. This stimulated discourse on the subject's privilege and freedom to petition the King. In January, a charge of lease-making was brought against an individual who had written a private letter that twice so many have signed since the proclamation, and that the petition constituted a national covenant. The author, a medical doctor with Jacobite sympathies, Archibald Pitcairn, was released after making a humble submission attributing his letter to drunkenness. This is like them getting these. Max Hill has gone after these tunnellers and he wanted them to admit they were guilty. They're not guilty. They got acquitted. I don't know why. He's done it again. We've just got the paperwork for Angela Ditchfield and now for Town and Country Planning Act, and now Max Hill's doing it again. Exactly when I said that, I said that the tunnelling project was the best action, and they're spying on us. They're listening in and they're playing chess games, and they brought this action against the tunnellers also because of the action with the action. The legal case with the Dartmoor, which has actually been won now, while camping on Dartmoor. The council could not, in law, prescribe the ways and methods of the subjects. Some subjects, inventing law is creative. But ideas and thoughts are also creative and come from nowhere or are brand new and never been thought of. So you can't always prescribe the ways of subject because subject is unpredictable and creative by nature. That's the nature of thought itself. Collective positions were presented. 1,700 was presented to William in October, followed by a second wave petition to Parliament from 11 shires and 7 proposing. Because the Lord of the Articles have been abolished, right? So it definitely has been abolished, this Lords of the Articles. Now, this is probably, this bit here of information here, to me, is as valuable, if not more valuable, than finding the Scottish version of the right to petition includes being imprisoned. It's illegal to be imprisoned. And this is, they were able to present the Shire and Burgh petitions in open Parliament without any vetting because of the abolishment of the Lord of the Articles. So what is Martin Day playing at? This here is pertinent to Martin Day MP and the rest of the Petitions Committee. I need Andrew Bridgen needs to see this and read it. Although I don't know, what his opinion is because he was trying to prosecute Matt Hancock or claim against him. He was trying to sue him. This is important because that means my petition submitted to Parliament Petitions Committee shouldn't have been rejected. And they lied anyway, made up excuses saying that they didn't know what I was asking. And it doesn't help when they restrict the words or disallow any evidence from off-site, even from your own drive or file. It's the evidence, the accuracy of the evidence is to be debated and decided. The people, at the stage of collecting the signatures, the people look at the information and read it, and they decide whether they think that it's right or not. So that's important. There's nothing that I've noted on page 11 that I wanted to talk about. The Earl of Marchmont, they're on page 12 now. No other use than to make kite. The Earl of Marchmont tried to stop the reading of the address. This is an address on the grounds that they were seditious, while the Duke of Argyll treated them with contempt, saying they were of no other use than to make kites. It had been objected that the claim of right protected petitioners. They were submitting cases, petitions, claims, and these members of the Parliament, dukes, lords, didn't want to read them or address them, said they were seditious or hold them with contempt. This is what the Petition Committee are doing now to us, saying there were no other use than to make kites. Well, we could do with making kites to promote them, really. So this is more evidence why we've got these rights, the right to petition without being held to commitment. It is the natural right of all the subjects to present their grievances and petition for remedy thereof. The problem is, right, one thing I don't like about this is that since Mark Zuckerberg got very rich from basically other people's adverts, he's got very all his money from advertising. He basically just shows other people's adverts like an online newspaper. Even though it's social media, he's invented all these block and ban buttons, and we're all getting very frivolous with them, whimsical with them over next to nothing. I'm going on certain websites now, and people just, if you say the slightly wrong thing or they take you the wrong way, that's it. And they're actually, it is in business and commerce. It's actually, I strongly believe that these laws on discrimination. You see that Nigel Farage has got this case now about the banks discriminating against us, right? And saying that you can't have a bank account for political parties or whatsoever, which has caused a lot of uproar on GB News and so forth, if you watch Nigel Farage. What's happening is that I think the government, the royalist movement, the authorities were paying very keen and close attention to the development of these websites and social media. And the government wasn't really, in a way, the Prime Minister, Rishi Sunak, he wants to enact many, many laws so you can't discriminate against things, so everyone's treated equal. But what's happening is all these platforms and technical devices we've got are giving people their own administrative powers where no one's actually moderating them or checking to see whether they are breaking the law and discriminating against other people by overusing them. And it's antisocial because people aren't actually able to express their grievances with anyone anymore because they'll just get blocked. And then even if you get a lawyer and you haven't got their address other than the internet, I have had it where I paid for a lawyer to act and they just blocked the lawyer. So it would be all right if you could just, block the parliament, wouldn't it? Or, block the courts or block, anything, if you just didn't want letters from the government anymore, the taxman or, whatever. What's ironic is many, many people would like to block all these building applications that have been put next to them or opposite or in fields with horses. And they would really, really like to block them very easily. In theory, it should be easy with all these social media sites. But firstly, the council aren't putting strong value to them. They're not regarding the objections and complaints with any weight. And they're also lying in the chamber like the petitions committee are as well, and Max Hill. And this is why these big corporations get permission eventually, even though people object year after year after year, but then get tired, because you shouldn't have to object for an objection to something in your village should be for life. So they're wanting, and one way how people can come together to object against the council or the government is by coming together socially. Now, if you introduce tools that actually get the public to argue amongst themselves and not talk things out and just block, you're creating a network of antisocial barriers, and it stops people forming political parties and movements themselves in their local areas. So then they don't end up going against Labour or the Tories, and really Messenger or Facebook groups should be very easy to get these signatures, but for some reason the administrators of the groups aren't well educated. Mark Zuckerberg and Google and all these websites do not seriously explain that people have political rights even on private groups and platforms, and they should be upheld and respected, and that is actually undermining the law, and it's preventing people from coming together. And really, they've made it very cleverly. And I don't even really think Mark Zuckerberg, Nick Clegg's with Mark Zuckerberg, because Nick Clegg's the global president for Facebook, or was. Someone, Tony Blair, these people with these mechanisms of implementation with their World Economic Forum, what they're doing is they are encouraging antisocial behaviour, so people can't really use this amazing technology extremely effectively to actually block the big corporate entities and even oppose the council to a very, very proficient result. Because of they've given everyone authority, and they're not telling people to they're not being, the platforms aren't actually moderating people's discrimination. Actually, it's actually creating a new forms of discrimination, whimsical discrimination, even for no reason at all, even in business. And what that does also is stop people going to smaller businesses and buying from each other if they end up falling out, and then they end up just buying from Amazon or eBay. One effect of that was Donald Trump, when he put the postage prices up from England to America. Then it was too expensive to buy anything from eBay, and we used to talk to a lot of Americans on eBay and have friendly relations. And you didn't buy second-hand things anymore, or things from individuals in America. So what happened is more and more people just resorted to Amazon. So it gives money to Jeff Bezos, which is in the scheme of things of how they want to do it. Because Bezos wants to take over the NHS, wants to take over everything else. Everything's either under Google or Facebook, and then Elon Musk now taking over Twitter. So we're being forced to go to these big corporate entities that are taking over everything, that have all these policies. Yes, you might be able to return things and send things back and get customer service, but they really, really don't want you, like on eBay, you're not allowed to talk to people about this, talk to people about that. They're destroying the free speech that we spoke about earlier, speaking in private. They don't want you mentioning other shops while they're in their shops and so forth. Might compromise their policy, but nonetheless, it's very, very discouraging of community patterns. The old Labour Party, not the Starmer Labour Party, the Ken Loach Labour Party, the George Galloway, the Jeremy Corbyn Labour Party, is all meant to be about this socialists. But really, the Liberals were the socialists. The Whigs in here, the Liberals were the socialists because they made these political rights. These political rights and liberties are Whig. They're confirmed as Whig beliefs. So George Galloway, when he says, he doesn't like the Liberals, he wouldn't even be able to have his programme. He wouldn't even be able to have the Working Party, or speak freely if it wasn't for the Whig policies. I don't think Galloway quite is going back in time as far as this in his, 1950s childhood, unfortunately. People have to be, because if you don't talk about a problem, it can bubble under the surface and so forth. Sometimes it's better to express it. And then we're on to the last page. That was page 12. We're on to page 13 now. And I've just highlighted, this video is going to be like 2 hours, but at least I've commented on this and I can send it to the professor and add it to the rest of the research. I don't know if this will add any more to the papers we've done, though, because all the things in here really is confirming what we suspected and what we kind of knew to be true anyway. But it's extremely valuable to have the confirmation that we know the Petitions Committee are vetting and obstructing and pruning things without right, and, the Lord of Articles was abolished. That's very good to know. And the wording for the right to petition immunity and confirming it includes imprisonment, and also the fact that it's confirming some context for it. People talking about it from the time, referring to it, claiming that there was a large part of it to try and restrict the oppressing royal powers, which is now what's happening with the Crown Prosecution Service. They're even trying to, not even these rights themselves, but modern entire acts of law, 1990, 2007, completely, absolutely overlooked, ignored, denied existence by Max Hill, Director of Prosecutions, who's the spitting image of, police chief officer. they've got no interest in people's rights. They're not allowed to have anything to do with it at all, whatsoever, nothing. It's not a matter for prosecutions. And the matters are, it's a case to, like a criminal case or civil case, to the Parliament, either of the Houses of Parliament or King. A proper case with immunities like you get if you're a witness in a criminal case or for an inquiry. In fact, you can petition for an inquiry. Why would you want to petition for an inquiry if the police themselves were the subject of that investigation because they've been putting out illegal road signage around England or other crimes? Now they're actually engaging in more crimes against these people, more abuse of the law, when it's even to the point where not only is the statute there, it's been explicitly and thoroughly codified that you can do these things for advertisements and defines them. And still, absolute defiance. These people, it's like Rees-Mogg on GB News. He sat there, we've even had the select committee that Professor Tim Wilson put on his programme of Ofcom, telling Ofcom that they're not doing their job properly. This select committee guy, who I thought was brilliant, it's GB News, it's called GB News. And they won an award for being the best news programme. Yeah, Rees-Mogg's not supposed to be on there while he's serving as an MP. And he's in complete denial. I don't think we're going to get Max Hill admitting that he's criminal, because it's Rees-Mogg is in the identical position. It's clearly obvious and blatantly been talked about in the open, on television, on Professor Tim Wilson's programme, in select committees. And the man is defiantly in denial of fact and truth. And I'm afraid that's what's happening with Max Hill. He's ignoring two acts of law from existing, and yet then he comes back for more. It's like he's on a suicide mission or something. Yeah, I think he's trying to run the CPS into the ground. Restriction designed to curb direct participation. The tumultuous petitioning, however, continued to be unacceptable, and laws against unauthorised convocations were deployed to limit unwanted addresses by subjects at large. Both in Scotland and England, decades of conflict with late Stuart monarchs had transformed the customary liberty into a constitutional right, hedged with statutory restrictions designed to curb direct participation. Well, this is the number of participants if they're talking about the tumultuous act. So the right to Westminster Parliament was an auxiliary right, allowing subjects to defend and preserve their primary natural rights for security, liberty and property. Although you must have a right to deliver to property. Well, you have got in service of notices gives that right. You're not guilty of trespassing when you're serving notices. It doesn't say how long that you can be there or not. It's got to be relevant, The police can't, if you're delivering and servicing notices or advertisements or actually promoting from the site that you're protecting or some part of it, it doesn't say how long you can be there for. It doesn't say how fast the police can drive in a police car. Is police speeding a public concern? The police just, he rolls his eyes and starts shaking his head when you start questioning what he can and can't do as a police officer. This is it. Many of these incidents, I think, have been set up by the police. I think it's police, terrorists, police, a lot of these strange stunts that appear in the newspaper through the police media office, press office, very strangely happen at very time, almost in response to certain things. And it makes you wonder if, they're police activists and they're trying to sway the public opinion through the news and newspapers in order to get what they want. So people don't want people to have rights, or they want people to be scared and want more security cameras. Because really, if those departments had been excelling in crime prevention, there wouldn't be any crime, just not even with the need of these devices. They'd have just found the criminals and solved the crime. It seems at the moment we're bringing more and more crime in. The statistics say that, the majority of crime now is from immigration and so forth. That's what the statistics say. If the police were so brilliant at crime, it would be self-defeating, because there would be less and less police and less work to do, and then you wouldn't even need the police force. We could go back to just doing it like on hue and cry like before. But anyway, so there were a number of important points in this, primarily the context and confirming things that we suspected. Also, the fact that Karin Bowie, the professor, has also acknowledged and recognised the contradictions and discrepancies that we ourselves find when we read it. So she also finds the same, which could suggest the professor believes there is a fundamental flaw with authority in the government in Parliament when they enact things. Could be. And then the Lord of Articles things as well. And the whole context, the only thing that Karin Bowie didn't do is look at the whole thing in context of the country prior to policing. Maybe she's got a paper on that, I don't know. But if she looked into immunities and privileges in what the public had prior to policing, but I think there's enough in here to confirm that this is an immunity law for government casework and to ensure freedoms in doing it and facilitate action. Particularly, it's all codified into modern law for the placement and use of advertisements and promotion. Should include online as well, websites, videos, YouTube. 38degrees and change.org are not following. Firstly, we're withholding emails, even though you're the person who created the petition and you've got data rights to it. And then they removed 3 of my petitions saying that they've got some sketchy signatures on it. Yet, invalid data or data that is in error, and it was proved that it wasn't my fault because I couldn't check them properly because they were withholding the data, they're discounted. If you read all of the legislation on referendums and elections and petitions, any invalid entered data is set aside at the end, discounted. Right? I didn't do it fraudulently on purpose. Someone else got it. It's impossible to, when you're petitioning and collecting statements anyway, it's impossible to be 100% sure that people aren't putting incorrect data or false statements. That's why all of the information has to be there so it can be checked. It's actually not 38 Degrees' role or position to check data on petitions. It's the role of the authority that you hand it into who's making the decision or check accuracy of data. They want to be a facilitator who provides petitioning website, right? And they've got data protection responsibilities, but not withhold your data from you, protect your data for you. And, you know, signatures are meant to be checked by us and by the council. And if it's incorrect, it's set aside, it's discounted. And particularly with the Inquiries Act, you know, when you're petitioning for an inquiry, the signatures are part of the evidence, but not the whole evidence. There's A and B in the first clause of the Inquiries Act 2005, A and B. A is the evidence that is the facts that the petition relies on, the case you're putting, the information that you're trying, and then B is the evidence of the public supporting it. which is the signatures. They're both regarded as evidence. And you've got rights to go about collecting evidence for proceedings and publish and promote advertisements to get witnesses to come forward and give statements and sign online as well. And 38 degrees, all of the photographs and videos and all of the updates you put in a petition, that is the evidence of the petition and the case. They can't delete a case to government. A third party cannot intervene in or remove or delete your petition to government. It's an official legal case. It's a legal campaign intervention by 5013C, but also, YouTube have said that, those 5013Cs are supposed to apply or do claiming they apply to everyone. 38 degrees are a facilitator, and there's certain things they can't do. They can't take a petition down or intervene in it, and they also they can't withhold the emails, the data. So my petitions have to be reinstated. It's in the 2011 Local Referendums and Petitions Act. And also they can't split the petition. A petition, every sheet has to have the name of the petition on it, and all of the data, the name, the signature, the address has to be included. What they were doing is they were generating copies of it for download to the people who were authorised to have a copy that didn't have all the data on it. There was some data omitted, and that's what Change.org are doing. They are not giving you all the email addresses. So when you download it, it's not the complete petition with the full data. Now, only people authorised to have a copy of it can have one. If you created the petition, you are authorised to have a full copy of all the data because it's your petition. They are the facilitator, so, they've got data protection to safeguard your data, not withhold it from you. And the council who the petition's to, the named party who the petition is to, whether it's a local council or a local council or government department or whoever, that person also, because it's to them and made for them, has the rights to the data. So generated copies have to be complete. 38 degrees and Change.org were omitting data from there. I think that is illegal and criminal. Yet what they did is they said that my petition had got dodgy email signatures on there, so they took them down. Yeah, I contacted the website that I got the promoter through, who was meant to be collecting the signatures, and they confirmed that I'd been ripped off and refunded me, and it clearly is not my fault. I wasn't able to see all the data properly while the petition was being run, so I couldn't check them. This is why in elections the spoiled ballots, the spoiled signatures are set aside and discounted, and then all the signatures for and against counted, and the ones that aren't valid are discounted. It wasn't my fault. It doesn't intervene in the petition running at all. And petitions can be actioned without any signatures. Some petitions can be actioned with only 1 or 5 or 10 signatures to local councils if your local council supports it and the council support it. Also, on basis of the facts. If something's broken, like a swing or a slide in a park, and it's dangerous, and you've got photographs, and you get an assessment, risk assessment, and so forth, it's a strong case on the facts alone. This is the thing with the Inquiries Act. It says that if you lay to a minister either the facts or the evidence of the public support to merit an inquiry, it's either or. It can be done purely on the facts and evidence, or on the weight of the public concern for the matter. Either or. It's all evidence, like a legal case. And 38 degrees don't realise that these petitions are very serious cases to government. if they want to host a petition site, they have to understand that they cannot intervene in these processes. And they've got everything on lockdown. Every time you message another member, they have to read it and vet it and check it. And every time you want to alter your petition, but they're a third party. But they're claiming, oh no, we might be liable, we might be liable, we might be liable. But what they're actually doing is they're behaving as if they are the lord of the articles, when they're not. Because Lord of Articles was abolished. They merely provide a website and let you register a petition and upload photos and data, and they make sure it all works properly. They're overstepping their responsibilities, Mark. And that is my other case that I want to get some help with in a legal writ. Because Change.org and 38 Degrees they've been doing it and making very financial gain out of people donating money to them at the detriment of people actually having their own data that they've collected, and also with unlawful interventions in between. And something needs to change. I need to make a case to 38 Degrees and Change.org as well as a case to YouTube, because they removed 3 of my channels when I believe that there's immunity and the legal requirement to service notices to the public, deliver through a public access platform that says it will comply with the rights and laws of England and apply the rights of laws in England. This is Paul Groves, the legal director. And I only broke a minor policy clause anyway, but they claimed it was a serious breach when it's got no criteria for a serious policy breach. I've got a document that proves that, which they've just ignored it. YouTube admitted that they gave a strike wrongly against one of my other channels, but it's all coming down to this one video. They're saying that this thing exists where they can't intervene in elections, but it's also they can't intervene in petitions. They can't intervene in petitions. There's a legal requirement to publish and serve notice and collect evidence. And unfortunately, Neil Mohan currently doesn't get that. I'm being punished and I've had my website taken down. I need to take YouTube to court to get my channel reinstated. I'm going to take action against 38 Degrees if they don't put my 3 petitions back up. There's a legal case against Parliament for unlawfully vetting and making up excuses that they can't understand what something says, right? And then we've got this Max Hill, who's completely illegally prosecuting people by completely ignoring 2 full complete acts of law, which are the acts that contain the codified law to apply the immunity, and which was specifically made for that purpose. He wants to ignore they exist so he can get a load of criminal damage charges, which is false charge. And then when you pull him on it and you get some documents submitted to the courts to complain, he goes and gets these tunnellers who were acquitted for trespassing and actually talks them into admitting that they are guilty. Yet you can be on site on private property, even without permission, to serve notices, and it doesn't say how long for. And it was they were there to protect something as well. I think this right to petition, not just private meetings, free speech, public gatherings, the advertising and promotion, gathering of evidence, investigations, it must mean to protect somewhere as well. Because it only makes sense that if I've got a case that people are supporting to protect something, there's nothing to protect. If it is allowed to be destroyed and destructed, you've got no case. And that's what they've done to me in my area here. There were some beautiful things in our area that I liked, and they destroyed them and attacked them. They I think they snuck building on a doctor's surgery that I really liked, while COVID was on, distracting people, without putting a planning notice up. And then there was some hacking of the records on the council which said that it had been done 2 years ago, and I'd been going past there on the bus every day looking at it. It hadn't been done 2 years ago. And then a lady said there was a mysterious incident crashing into the wall. There was various cones on the corner for the pavement being done. It's been stolen. Some of these council building and planning people are also corrupt, and that's where all this illegal road signage and illegal planning and illegal contractors come in. They put a curb outside our house, a bright white one which looks out of place, after I complained about some other curbs down the road. They lowered the curb and all the water's flooding onto it now, and it should have been left. I complained that I wanted the original curbs put back, and then a mysterious white curb appeared from nowhere, alone, by itself, without any other works near it, almost as if it was in retribution from the council. There's a lot of things going on. I believe that the royals, the government now, are playing chess games, particularly when it comes to land and BT, getting telegraph poles on land, putting sewage lines under land in the hope that, you know, they're trying to claw at land in a chess game. And we could easily object to it by very, very large numbers of petitions. There are so many people who want to oppose housing and want to oppose, developments that are taking down trees in local areas. Save the trees, save the trees. But we don't seem to be getting the volume of signatures. I think that there's some algorithm going on these platforms. For one, I was doing very, very good collecting signatures on Messenger, and just at the peak when I was getting loads in, they changed it, and you could only send the maximum number a day. And then people who were helping me get signatures had their daily allowance lowered. It said you could tag 50 people. When I tagged 50 people in a group, I got 20 signatures, and I kept doing that, and it was working really well. And then suddenly, when I put the link, it was just deleting it. Mark Zuckerberg's admitted to removing things that were debatable. Well, it's more than debatable. We've got a right to do it. It's illegal to intervene. He claims the government told him to do it, but we don't know whether he did it or his team or this 77th Brigade intervened or some unknown entity. I've got a strong feeling that there is a group which is very similar to the Anonymous movement, but it is a royalist group or a Labour Party or Tory group that has hackers, and they possibly connected to the contractors like Balfour Beatty and Care, and they are some of these people who complain against Extinction Rebellion and Just Stop Oil, but I've just got a feeling that they are hacking into these websites and stopping people from seeing your posts, or lowering the visibility. Same how YouTube have done with my YouTube channels, so not many people see my YouTube channels, and then they made it so I couldn't be monetized. This is all what these rights were made to prevent. So when opposing the council or government, you're on an equal footing. If the authorities have got the use of advertisements, promotions, all these facilities in our taxpayer money, we have to have equal powers at our means to equally and fairly oppose them. And the problem is that now most of the corporate entities are the ones who have all the money and they own all the platforms, and they've got their adverts everywhere, and they've taken over the streets and the pavements and everywhere with these things. And we're struggling to even be able to paint a wall. And we can't afford to use their facilities. And even if you're opposing them, when you're buying adverts on their platforms, they're making money out of you opposing them. So they can't lose. It's like if you flick a coin, if it's heads or tails, they win. So with some of these advertising companies who are owned by some of the companies in the food industry who are opposing, are causing bad health, we're using their advertising facilities, and charities are advertising on Facebook, and Mark Zuckerberg's making money out of them, and Google's making money out of these charities. Yet these charities, many of them are opposed to the oil and gas, which are owned by these companies. So you're promoting your campaign in their newspaper or on their advertising, billboards, and they're making a profit out of you when you're opposing them. Now, if you use the right and just go and paint on it anyway without prosecution, they aren't making money out of you. And it's a very good opposition because it's blanking their advert out. This is what Max Hill doesn't understand, what we're up against. The political actions are superior and have the legal precedence over all others, even if you're swampy. But because of coffee shops and money and handshakes and business suits and degrees in law and business deals, Max Hill sees these companies and orchestrations as